You're walking home, or maybe you're sitting in your car. And out of nowhere, a police officer walks up to you and says the 4 words that trip up more people than almost anything else in this country. I can smell cannabis. Your heart drops. Maybe you haven't touched anything illegal in your life. Maybe you just left a party where someone else was smoking. Maybe you've got nothing to hide at all, but suddenly you're being searched on the street, or your car is being pulled apart, all because of a smell that nobody else can check or verify. So what do you actually have to do in this moment? What can the police actually do? And more importantly, what should you say? In this video, I'm going to break this down step by step. What the law actually says about the smell of cannabis, the exact phrases that protect you, and the mistakes that get people in serious trouble. Let's get into it. Before we talk about cannabis specifically, you need to understand the basic rule. In England and Wales, the police cannot search you just because they feel like it. They need what's called reasonable grounds for suspicion. This mostly comes from 2 laws. Section 1 of the Police and Criminal Evidence Act 1984, known as PACE. This covers general stop and search powers for things like weapons or stolen property. Section 23 of the Misuse of Drugs Act 1971. This is the one that specifically covers drugs, and it's the one that matters most for this video. Both of these require the officer to have genuine, reasonable grounds, not a hunch, not a feeling, not you looked nervous. There actually has to be something solid behind it. To help officers figure out whether their grounds are solid enough, the police themselves are trained to use something called the Go Wisely checklist. It stands for G rounds. What's the actual reason for suspicion? Object of search. What are they looking for? Warrant card. If not in uniform, they must show ID. Identity. The officer must give their name and number. Station. Which station they're from. Entitlement. You're entitled to a copy of the search record. Legal power. Which law they're using to search you. You are detained. They must make clear you're being detained for the search. If an officer skips these steps, that's not just bad manners. It can make the entire search unlawful. Keep that in mind because it's going to come up again later. Here's where it gets interesting, and honestly, where a lot of officers get this wrong. The law itself, Section 23 of the Misuse of Drugs Act, and the official PACE guidance known as Code A, doesn't actually say anywhere that smell alone is automatically enough to justify a search. There's no clear court ruling that settles this once and for all either, but here's what we do know. The College of Policing, which trains officers across the country, has said clearly that it is not good practice for an officer to base a search purely on smell alone, with nothing else to back it up. Officers are specifically told to ask themselves questions like, can I actually connect this smell to this specific person, and not someone else nearby? Could the smell have come from somewhere else? Another person who already left? A different car? Residue from earlier? Is my suspicion genuine? And would a reasonable person looking at the same facts agree with me? In plain English, the smell has to be attributable to you specifically, not just floating around in the general area. If you're standing in a group of 5 people and an officer smells cannabis, that alone doesn't mean he can search all 5 of you. He needs some reason to connect the smell to you individually. This matters a lot in practice, because in the real world, officers often use the phrase, I smell cannabis, as a shortcut, a way to get consent or get you talking, without doing the harder work of building genuine, reasonable suspicion. Knowing this gives you the confidence to ask the right questions instead of panicking. Here's something you need to know, because it happens constantly. An officer walks up and says something like, "You can smell that too, can't you? That's cannabis, right?" This sounds like small talk. It isn't. If you agree, even casually, even as a way to seem cooperative, you've just handed the officer exactly what he needs. You've turned a vague, unproven claim of smell into your own personal admission, and that admission alone can be enough grounds for a full search. The safest response to any question like this is simple. I'm not going to comment on that. You're not being rude. You're not obstructing anything. You're simply not helping build a case against yourself. Remember, the police's job in this moment is to gather evidence. Your job is not to hand it to them for free. Before an officer even gets to a search, there's often an earlier stage called a stop and account. This is simply when an officer stops you and asks what you're doing, where you're going, or what you've got on you. At this stage, you are not being detained, and you are free to walk away at any point. The single most useful sentence you can say in this moment is, "Am I being detained, or am I free to go?" This forces the officer to clarify the situation. If the answer is, "You're free to go," then you can simply leave. If the answer is, "You're being detained," then a stop and search is now happening, and different rules apply, which brings us to the next part. If an officer tells you that you are being detained for a search based on the smell of cannabis, here is exactly how to handle it, step by step. Step 1. Stay calm and don't argue. Arguing with an officer on the street rarely changes the outcome of that moment, and it can make things worse. Officers are trained to note down words like aggressive, uncooperative, or confrontational, and once that language is in a report, it can be used to justify further action against you. Calm and clear is always the better strategy. Step 2. Ask for the grounds you are entitled to ask and they are required to tell you. Can you tell me the specific grounds for this search? If the honest answer is genuinely just, "I can smell cannabis," with nothing else attached to it, no visible signs, no behavior, no admission from you, you can calmly say, "I understand that smell alone may not be sufficient grounds under Code A. I do not consent to a search, but I won't obstruct you." That second half matters enormously. You are allowed to make clear you don't agree with what's happening, but you should never physically resist or try to stop the search from happening. If you do, you risk being arrested for obstruction, even if the search itself turns out to have been unlawful. The fight over whether the search was lawful happens afterwards, with the solicitor, not on the street. Step 3. Don't answer unrelated questions. Once a search starts, officers will often keep the conversation going, asking where you've been, who you were with, whether you've used drugs before. None of this is required. A simple response works. "I'd rather not answer any further questions." This isn't the American right to remain silent from the films. The UK version is a little different, and it's worth knowing exactly how it works, which we'll cover next. If you've watched American shows, you've heard the Miranda warning. You have the right to remain silent. The UK doesn't use Miranda rights. We have something called the police caution, and it's actually a little more complicated. Here's the wording. You do not have to say anything, but it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. Notice that middle part is, it may harm your defense. Unlike the American version, staying completely silent in the UK can sometimes be used against you later if you bring up a defense in court that you never mentioned at the time. This doesn't mean you have to answer every question. It simply means the smartest move, if things escalate to a formal interview, is to say, "I don't wish to answer questions without speaking to a solicitor first." This protects you properly, because once you've said this, officers should stop pushing you for answers, and you get the chance to speak to a solicitor before anything you say can be used to build a case. Cars complicate things, and this is where a lot of people get caught out. If an officer says they can smell cannabis while you're driving or sitting in your car, they can potentially use Section 23(2)(b) of the Misuse of Drugs Act to search the vehicle. But there's an important legal detail most people don't know. The power to search a vehicle isn't really about the vehicle, it's about the person. In a case called R.V. Littleford, the court made clear that an officer must have reasonable grounds to suspect a specific person in the vehicle is in possession of drugs. Simply suspecting that the car itself has been involved in something isn't enough on its own. This matters especially if the car isn't attended, or if there are multiple people inside. If you're a passenger, and the officer's suspicion seems to be aimed only at the driver, it's worth calmly asking, "What specific grounds do you have to search me?" rather than just the driver. If there's genuinely no separate evidence connecting the smell or suspicion to you individually, no behavior, no admission, nothing you've said, that search of you personally may not be properly justified. And that's exactly the kind of detail a solicitor can challenge later. A few quick things to avoid, because I see people trip over these constantly. Don't say, "It's not mine." This might feel like an obvious defense, but it's actually an admission that drugs are present at all, which can strengthen the officer's case rather than weaken it. Don't get into a debate about the law on the street. Even if you know your rights well after watching this video, arguing legal technicalities with an officer in the moment rarely helps. Make your position clear once, calmly, and let it go. Save the real argument for later, with someone qualified to make it. Don't consent just to get it over with. A lot of people agree to a search purely because they think refusing will make things worse or take longer. In reality, saying "I do not consent, but I will not obstruct" protects your legal position without escalating anything. Whether the search finds anything or not, here's what matters afterwards. Get a copy of the search record. Under the Go Wisely requirements, you're entitled to a record of the stop and search, either on the spot or as a reference number you can use to request it within 3 months. This record will show exactly what grounds the officer gave, which matters enormously if you want to challenge it later. Write down what happened while it's fresh. As soon as you can, note the time, location, what was said, and the officer's name or number if you got it. Memory fades fast, and small details can matter. If it felt unlawful, complain properly. If you believe the search wasn't carried out correctly, or the grounds genuinely don't stack up, you can raise a complaint with the officer's own force, or escalate it to the Independent Office for Police Conduct, IOPC. In more serious cases, for example, if you were detained without proper grounds, a solicitor can advise you on whether there's a case for false imprisonment, or a challenge to how the search was conducted. Let's bring this all together. The smell of cannabis alone is a much weaker basis for a search than most people, including some officers, seem to think. The law requires genuine, specific, attributable suspicion, not just a vague claim floating in the air. Stay calm. Ask if you're being detained or free to go. Ask for the specific grounds. Say clearly that you don't consent, without ever physically resisting. And don't hand the police your own case by chatting away or agreeing to things you don't need to agree to. If you want to know what happens next, what your rights actually are once you're arrested, and the exact point where police must let you speak to a solicitor, check out the next video where I break that down step by step. See you there. Disclaimer. This video is for general information only and does not constitute legal advice. Every situation is different. If you're facing a specific case, speak to a qualified solicitor.